When it comes to Canadian PR card renewals, many permanent residents think I'm just a few days short, it won't matter. I'm here to tell you that's not true. Even one single day short of the 730-day residency requirement can legally lead to a refusal of your PR card application. And I've seen this happen many times. Today, I want to explain why this happens and what you should never do if you are short on days. Under Canadian immigration law, permanent residents must be physically present in Canada for at least 730 days within the last 5 years, not approximately, not almost, not close enough. 730 days means 730 days. If you are 729 days, you simply do not meet the residency obligation. Officers are not allowed to round up your day. Here's the mistake many people make. They apply anyways. They think maybe the officer won't check carefully, it's just one day, Canada is nice, they'll ask and I'll explain later. But once you apply and you don't meet the requirement, IRCC officers can actually refuse your PR card renewal. They can also start a residency investigation against you, or worse, issue a procedural fairness letter known as PFL, and in some serious cases, initiate loss of status proceedings. This doesn't have anything to do with Canadians being nice. Now, this does not mean you automatically lose your PR status. If you're short on days, there may be options like humanitarian and compassionate considerations. For example, the best interests of a child. If you're facing serious hardship, that can be another reason. You must have compelling reasons to justify your absence from Canada. But remember, this must be structured carefully and properly. Otherwise, you're risking loss of your status. Never hope for mercy. Instead, build a legal argument. If you're short even by 1 day, do not rush to apply. Do not rely on assumptions and guesswork. Do not file blindly. Every residency case is fact-specific and has its own nature. Sometimes waiting is better. Sometimes agency is appropriate. Sometimes travel history must be analyzed carefully. If you are below 730 days, even slightly, even 1 day, this is not a DUI situation. Don't do it yourself. Instead, get a structured legal assessment before you submit your file. Because once you trigger a refusal, fixing it becomes much harder. Those of you who have met your residency obligation, even by more than 730 days, you still have to convince the immigration officer and provide enough documentation to prove that you have been present in Canada. But if done carefully, yes, you can do it yourself. But if you are below 730 days, even slightly, even 1 day, this is not a do-it-yourself situation. You need to get a structured legal assessment before you submit anything. Because once you trigger a refusal, fixing it becomes much harder. If you need professional guidance, you can book a consultation through the link in the description, and I'll try my best to help you. Thanks for watching.